Hello friends, in the series on the income tax cases, today we will discuss another case on condonation. We have also discussed some cases in the previous deliberations, the cases which were based on condonation. Nowadays, the importance of filing various condonations have become very common and have become very important because various type of deductions are disallowed by the revenue just only because of the reason that forms are not filed on time, returns are not filed on time, and when the assessee files these condonation applications, the thumb rule is that the assessee has to show that there was some genuine hardship on the part of the assessee, that he has not filed the form or the return on time. So what is the parameter of calculating that whether in a particular case there is genuine hardship or not is a very subjective term, and it has to be construed very liberally according to the various judgments of the various courts. The present issue has been taken by the Bombay High Court in the case of Punjab, Kailash, Agarwal versus Assistant Commissioner of Income Tax, and this case has been reported in 464 ITR at page number 65. The date of the judgment is 8th April 2024. In the present case, the assessee was claiming deduction under section 80 IC, but the assessee forget to file the form 10 CCB because of the inadvertent error of the chartered accountant of the assessee. Because these are technical issues, the assessee generally do not know these things, so it is skipped from by the professional of the assessee. The assessee received the intimation under section 143 subsection 1 of the order, and in that order it was not mentioned to the assessee that why there is a tax liability and why the deduction under section 80 IC has been denied to the assessee. At this particular time, the assessee was not knowing the reason that why this deduction was not allowed to the assessee. The assessee filed the rectification application under section 154, which as usual was not disposed of by the revenue, in spite of various reminders to the department. Then assessee moved an revision application under section 264 to the Commissioner of Income Tax that my deduction has not been given and it should be given to me. But the Commissioner of Income Tax also arbitrarily rejected the revision application of the assessee by simply passing an order that the assessee has filed this revision application after 2.5 years, so it is beyond the limitation period. So the Commissioner of Income Tax disallowed the revision application of the assessee. Up to this time, the assessee was aware that why this deduction was disallowed to the assessee, and the assessee filed the form and applied for the condonation before the Central Board of Direct Taxes. When the matter was heard by the Central Board of Direct Taxes on the reason of the assessee that the assessee could not file the form 10CCB on time because of the inadvertent error of the chartered accountant of the assessee, then the CBDT rejected the condonation application of the assessee by giving a reason that inadvertent error of the chartered accountant is not a reasonable cause and it is not a genuine hardship of the assessee. The assessee did not have any option other than to go to the writ court. When this matter was heard by the Bombay High Court in the writ court, first of all, the Bombay High Court said that the order passed by the Central Board of Direct Taxes indicate its total disregard for the judicial orders. The court said that if an assessee is filing its claim late, then he is getting the benefit of that claim late. So in any sense, it cannot be said that the assessee is benefited by filing its claim late, because the liability of the assessee as far as the tax liability is concerned is increasing, and if due to non-filing of the form 10CCB the liability of the assessee of tax is increasing, then it can be safely assumed that it is a genuine hardship. So the court quashed the condonation quashed the rejection order of the condonation passed by the Central Board of Direct Taxes and directed the AO to take up the rectification application filed by the assessee under section 154 and do the needful. The court also said that in the present case, the rectification application should not just be disallowed only on the ground that it is not a mistake apparent from the record. Friends, this case is very important nowadays because when we file the condonation application before the Commissioner of Income Tax or the Central Board of Direct Taxes, then they try to just keep out the assessee from the definition of the genuine hardship, while it is the precedent of the various judgments of the courts that the genuine hardship should be constituted very liberally and a meritorious matter just not be thrown out of the box just because of the reasons that there is no genuine hardship. At the end of this video, once again I am repeating the name of the case. The name of the case is Pankaj Kailash Agarwal versus Assistant Commissioner of Income Tax, and this case has been reported in 464 ITR at page number 65, and the date of the judgment is 8th April 2024. Thank you, friends.